Hi, my name is Elizabeth Walker. I'm an Associate Director in the International Student and Scholars Office at the University of Texas at Dallas. This session is called The Journey from F1 to H1B and Beyond. I am going to be presenting the F1 side, and then David Swaim, who is here with us, is going to present the H1 and permanent residency piece of this session. David, would you like to introduce yourself?
Certainly. Good evening, everyone. I will be talking to you in a little while, as Elizabeth said, and we also have some written materials that I believe are online, and I will mention those in a little more detail once we start my part.
All right, so we're going to go through the first set of slides, and then we're going to take a break and we will address questions from the chat. So you may, while you're watching, if you think of questions for me or questions for David, you can put them in the chat and we'll address them in the question section. All right, the objective of this presentation is to educate F1 students on an optional journey after graduation, highlight key elements in maintaining F1 status on this journey, clarify travel requirements and challenges, and clarify requirements for a driver's license or social security number. So the journey begins. Your journey from F1 to H1B begins with your program completion date. For F1 purposes, your program completion date and your I-20 end date are the same thing. So your program completion date will be the last day of finals in the semester in which you graduate. And this will be in your graduating semester. Okay, so after your program completion date by immigration law, you will have a 60-day grace period. During the 60-day grace period, you may apply for your 12 months of post-completion optional practical training, apply for an I-20 for a new academic program, have your CVIS record transferred to a new educational institution, apply for a change of status to another non-immigrant status in the United States, or depart the United States. Okay, so optional practical training is what you can apply for to do after you graduate. It is off-campus work authorization that is directly related to your major. It is called post-completion optional practical training, and it is 12 months of off-campus authorization that begins after your program completion date. You may apply for post-completion OPT up to 90 days before your program completion date or during the 60 days after your program completion date. During the post-completion OPT, you are eligible for up to 90 days of unemployment. During your post-completion OPT, you must report to the ISSO any change of your name, address, or employment within 10 days of the change. And while you're on post-completion OPT, you can take any job in the United States that is at least 20 hours a week and directly related to your major and your educational level. Okay, so after post-completion OPT, you may be eligible for the 24-month STEM extension. The 24-month STEM extension directly follows an authorized period of post-completion OPT. Students may apply for the STEM extension during the last 90 days of their post-completion OPT. The application needs to be based upon a student's most recent STEM degree or on a STEM degree that was conferred within the past 10 years. And students may be eligible for a second STEM extension based on a degree at a higher educational level. Students are only eligible to apply for the STEM extension if they're in a period of post-completion OPT. Okay, so more eligibility requirements. In order to be eligible for the 24-month STEM extension, students must have a specific major in the science, technology, engineering, or mathematics areas. And there is a list of, you can link to the list of STEM majors on our website. Students also must have a job or a job offer from a company registered in the U.S. government E-Verify database. All right, So during the 24-month STEM extension, students are eligible for an additional 60 days of unemployment. Students may also work up to 180 days beyond their post-completion OPT end date while their STEM application is pending with USCIS, because sometimes it doesn't get approved before your post-completion OPT ends. Just like post-completion OPT, students must report any change of name, address, or employment within 10 days. When students change employers, they must also submit something to the ISSO called the I-983 training plan. Additional requirements during the 24-month STEM extension. Students on the STEM extension of OPT have an additional reporting requirement. It is the validation requirement. Students must submit a validation report to the ISSO every 6 months during their 24-month STEM extension. Students can report employment through the SEBP portal on their own, but they may not do the validations. Those can only be done through the ISSO. Students must submit a 12 and 24-month employment evaluation on the I-983 to the ISSO. That is part of the validation requirement. During the STEM extension, students may be employed by an E-Verify employer in a position that is compensated, so it must be paid. It has to be at least, well, it has to be more than 20 hours a week and directly to related to their major. So one key difference between post-completion OPT and the STEM extension is the students on post-completion OPT can do volunteer work. Students on the STEM extension cannot. Their employment must be paid. All right, H-1B. So often students who are either on post-completion OPT or the STEM extension look for an employer who might sponsor them for a change of status from F1 to H-1B. We're just going to talk about it a little bit, and David will go into it in much more detail. H-1B is a status for individuals who will perform services in a specialty occupation. The H-1B cap is an annual fiscal year limit of $65,000 for the regular cap and $20,000 for students who have master's or higher. Next slide. All right, so we have H-1B support services. Often students who are going to be submitting an application to USCIS for a change of status to H-1B need copies of all of their previous I-20s. If you need them from UTD, you can submit an immigration document copy request through iComment. If you are eligible for the cap-gap extension of OPT, meaning that you may be eligible for an extension of F1 status and work authorization between your OPT end date and your H-1B start date, you can submit a request to the ISSO for a cap-gap I-20. You can also do that in iComment. Okay, more about cap-gap OPT. Cap-gap OPT can help you bridge the gap, like I said, between F1 status ending and H-1B starting. Cap-gap adds an automatic extension of F1 status and/or work authorization until September 30th, depending on a student's OPT end date and filing date. Filing during your OPT period will extend your work authorization and status. Filing during your grace period after OPT will only extend your F1 status, meaning you could stay in the US in F1 status, but you would not be able to continue working. In order to be eligible for the cap gap, you must also have applied for a change of status in the US from F1 to H-1B. Applicants who apply for consular processing of their H-1B, meaning they will have to go back to their home country to apply for the H-1 visa, are not eligible for the cap gap extension. And you must be the beneficiary of an H-1B requesting a start date of October 1st to be eligible for the cap gap extension. All right, additionally, during the cap gap extension, the 90-day and or 150-day limit of unemployment days still exists. and students who are on CAP-GAP must continue to report any changes of name, address, or employment to the ISSO within 10 days. If you want to learn more about the CAP-GAP extension, you can go to this link at the bottom of the page here. All right, if your H-1B application is approved, please submit your final post-completion or STEM OPT extension reporting form to the ISSO in iComment with your I-797 H-1B approval notice and indicate that you are changing your status. The ISSO will update Orion, the university database, to reflect your new status, and check SEVIS to ensure that your F1 record was completed. Your F1 record should autocomplete as of October 1st if you've been approved for an H-1B subject to the CAP. If you are on the STEM extension, you will also need to complete and submit the final I-983, including the final evaluation section, because this will be your final reporting before your status changes. Travel. So it's important for you to know whether you can travel on post-completion OPT, CAP-GAP, or STEM. So during the STEM extension and post-completion, students should have a travel signature within the last 6 months, a valid passport, a passport that's valid for at least 6 months into the future, a valid F1 visa and EAD card, additionally proof of employment. Keep in mind that it is more difficult for a student to try to renew their visa, F1 visa, when they are on OPT rather than when they're in school. During the CAP-GAP extension, it is not advised for students to travel outside the United States because to come back in the US, you would only have the CAP-GAP I-20, not an EAD, and you're also showing that your intent has changed because you have applied for and possibly been approved for an H-1B. After the H-1B is approved, all applicants will be required to apply through an in-person appointment interview to receive an H-1B visa. Right, so if you leave the US during your OPT or your CAP-GAP period, and you want to come back into the US after your H-1B start date, on your approval notice, you could no longer return in F1 status, you would have to return with an H-1B visa. Okay, driver's license. So just to be clear, we know students still need a driver's license if they're driving a car to get to work, etc. when they're on OPT and CAP-GAP. While on post-completion OPT or STEM OPT, you will need a valid EAD card to renew your driver's license. During the CAP-GAP extension, your local DMV or DPS office will use the information on page 3 of the CAP-GAP I-20 to confirm your status. So if you need to renew your driver's license, you would need to request the CAP-GAP I-20 from the ISSO. Upon receiving your approval notice for H-1B status, you should wait 10 days until after you've received your notice and then return to the DMV to get your driver's license renewed. Non-immigrants must return to the DMV every year to extend their license for their period of stay. So it will have a fixed approval date. Okay, Social Security. The SSN application can be done as part of the post-completion OPT application through the Form 765 if you don't have one prior to applying for post-completion OPT. If you do not apply for the SSN as part of the OPT application process, you must have your EAD card and the start date must have been reached to apply for a Social Security number. During the STEM extension, you should already have an SSN because you would have worked on post-completion OPT, and same for the CAP-GAP. Okay, finally, we're going to talk about our advising services. So this was a quick preview of post-completion OPT, the STEM extension of OPT, and CAP-GAP OPT. If you have future questions about any of those, please visit the advising services page of our website. Okay, you can send us a direct question through the Ask an Advisor in iComment, ask an advisor e-form, and it will be responded to by an advisor. We have live chat available on Mondays, Wednesdays, and Fridays, and you can also make a virtual appointment to meet with an advisor on Mondays, Wednesdays, or Fridays. Okay, resources. So you may want to take a picture of this page. This is also being recorded and will be posted on our website. These are lots of good resource links for you.
I think that's it for us, Lissa. Did you want to take a few minutes to answer any questions so far?
Yeah, I am happy to answer any F1 related questions, and then you can
the session's not over for the person who just typed. We're about halfway through. This was just the first part. All right. So does anyone have any questions about anything so far? The text chat, sorry, is open for anyone who wants to ask questions. Okay, so we've got one question. If I'm working 2 jobs on STEM OPT, 40 hours each, and H-1B is filed by one employer, can I continue to do 2 jobs until October 1st?
Yes, so as long as you're still on the STEM extension of OPT and your status hasn't changed to H-1B yet, you can work for multiple employers on the STEM extension.
Right. Any other questions from anyone
I have a
about?
question.
Oh, go for it.
Along with kind of in the same vein as the last question. Are people in OPT allowed to work more than 40 hours a week?
Yes, so on post-completion and STEM, they have to work on a minimum of 20 hours a week. There's no upper limit to the number of hours they can work.
And so that includes multiple employers as well.
Correct. So they can work for multiple employers and they can work full-time. There's no ceiling as to how many hours they can work.
Great, great. I get that question a lot, and I don't think I've ever answered it the same way twice.
Okay, if there are no more questions for me, then I'm going to hand it over. Oh, wait, we have one more question. Oh, okay.
A few more questions.
Okay, I guess I'll answer a few more questions and then hand it over to David.
Okay, so I have 1 year on OPT before starting a PhD here at UTD. Am I eligible for the 3-year STEM OPT after completing my PhD?
Okay, so in order to be eligible for the STEM extension, so let me take a step back. F1 students are eligible in general to apply for the STEM extension, the 24-month extension twice, period, like twice their whole life. To be eligible for the STEM extension, a student must also be in the last 90 days of their post-completion OPT. So if you're going to move from OPT at the master's level to the PhD program, in order to be eligible for the STEM extension, you would need to apply for and be approved for post-completion OPT at the PhD level. And then in the last 90 days of your OPT at the PhD level, you could apply for the 24-month STEM extension.
All right. Next question is, this might be a bit more for David. If my company applied for an H-1B petition before joining, can I change employers?
Is that for me?
Yes.
I don't think we could answer that one.
Well, what period of time are we talking about before the H-1 change of status is granted?
Yeah, it sounds like if they've applied but not approved yet.
Well, then sure, you're still in OPT status, so you can work according to the parameters that Elizabeth just alluded to. So the fact that you filed for H-1 really doesn't have anything to do with your status until it's approved.
Right. So in terms of OPT, right, exactly. There's not a problem with you changing employers while you're on OPT, but that could have an effect on the H-1B application that you already have pending.
Right. As of October 1st, you would have to be working for the company that filed the H-1 petition. And it doesn't matter who you're working for until then.
Right. Okay. The next question. So for a paid intern, oh, hold on. Let me read this question. Oh, paid position. So this person is asking if the paid position requirement is only a STEM major requirement. It's only a requirement during the STEM extension itself. It's not a requirement during the first year of post-completion OPT. The recording is going to be posted on our YouTube channel. We'll make sure to share that once it's posted. And then it looks like we've got one more question, and then I think we'll move on to David's presentation. Okay, so I'm graduating in May. I applied for my I-20 with an EAD start date of June 20th. I want to start working from July. Does that cause any negative impact on my profile if I start a few weeks late after the start date on my EAD?
All right, so you do not have to begin working on the start date of your EAD. However, please keep in mind that any days, so between the start date and the end date of your post-completion OPT EAD card, you are allowed 90 days of unemployment. So if you start your job a few weeks after your EAD starts, those few weeks would be considered as days of unemployment and days subtracted from your 90 days.
Okay, so I think that's all the questions we have for now on the first part. So David, whenever you're ready, we'll start with your part.
Thank you, Elizabeth and Lark. That was great. I always learn something when y'all do that. So I guess the first thing we need to do is what I said before. There is online a manual about the H-1 process. I'm not sure how that's accessed. It's probably on the ISSO website somehow. But I'll let Elizabeth or Lark explain that to you. The important thing about that information is that the H-1 section, which is actually a very small section of that, is not current. So you might want to make a note. It's a work in progress, but it does not refer to the lottery or how we apply for the lottery. So please make a note that it is not up to date on the H-1 section. Everything else is up to date and is correct. You guys, as students at UTD, have one of the best international student offices in the country. And I know that because I give seminars at a lot of different schools. So I know which schools have good ones and which schools don't. And you guys are very fortunate that this is, if not the best, it's one of the best, both in terms of their expertise, but also I'm not sure that the care is the right word, but their dedication to the students is remarkable. It's also a great resource. You guys need to take advantage of it, both mainly when you're in school, but even a little bit after you graduate, because you've got all these requirements for OPT. And I cannot emphasize enough that you have to learn the rules for OPT and STEM OPT backwards and forwards. The biggest problem we see in our law firm, without question, is violations of the OPT rules. You always want to go to a lawyer for happy things, like getting an H-1 or getting a green card. You don't want to go to a lawyer for unhappy things, like your OPT has been denied or you've been placed in removal proceedings because of something you didn't do in your OPT. So I encourage everyone to become an expert on OPT and STEM OPT. And believe me, you will regret the day that you do not do that. So let's make sure everybody is an expert. You have wonderful information online, and plus the international office is constantly giving, if not seminars, they're giving updates and reaching out to students. So take advantage of that. So that's about the school. About us, in case you're wondering, our firm started giving this seminar at UTD in 1982, which is before most of you were born, I think. And I started giving it in 1991, which I think is also before y'all were born, which makes me very old. But I love doing this, and we've been doing it for a long time, and it's very helpful to me because the questions and the information from the ISSO always educates me. So I get a lot out of these seminars as well. And last but not least, we need to talk about you guys for a minute. One of the things that I think does not get enough attention, and it should, is the accomplishment that you guys have already had. It is a very courageous and very smart person who can leave their home country and go to a very, very strange place with very, very strange people and start school, get a degree, go out in the workforce. You should applaud yourself because it's a rare individual that can do that successfully. And you guys are well on your way to doing that. So bravo to you guys just for being here. Okay, first thing, let's go with the first slide. We're going to skip some of these because Elizabeth already covered it, or we should just skip it. Go ahead and put everything up. There we go. That basically explains what we're going to do this evening. We are only talking about employment-based immigration. So if you want to get information about family or asylum or investment, this is not the seminar to go to. I will, however, answer questions. As a matter of fact, if you guys attend this seminar, which obviously you are, you can email me at any time, and I will respond to your questions. It's free. We don't charge for that. But because you came to the seminar, because you're a student at UTD, I'm more than happy to help. So if you do have a question after tonight, and it's something that, which is rare, the ISSO can't help you with, please email me and I will be happy to help you. Okay, so let's get started with the H1. And Lark, I think we can skip the first, so skip that one, that one, that one. And we're not going to go through that. So, okay. Now, this is the whole enchilada. This is the important thing about what we're talking about tonight, is that you're going to have an employer to sponsor you. The H1 and the green card are not things that you can do by yourself. So how are you going to get a company to do that? Well, the way you're going to do it is educate the company, if they don't already know, that you bring with you a very, very good, positive, and that is retention. What that means is how long you stay with the company. Most U.S. citizens leave their first employer after a bachelor's degree in 22 months, so less than 2 years. You guys, because of the way the immigration system works, are going to have to work with an employer for at least 5 years, and probably most of you closer to 7. And if you were born in India, much longer than that. So as an employer, you guys are the best thing around because you're going to be stuck working for them while you go through the immigration process. And U.S. citizens and permanent residents don't have those restrictions, and they typically leave within the first 2 years. So the employer has wasted all the training time and giving you experience, and then you go across the street and work for the competitor, whereas F1 students do not do that. In fact, can't do that. So that's the point we want to get along to employers. Most of them, or a lot of them, know that already, but you will encounter small companies, especially, that do not know it. And once they find out, a lot of them are very excited about it. So that's the thing we're going to do today, is get you guys a job with an employer, and that employer is going to take you through the immigration process. So let's go to the next one. These are the requirements for the H-1, and they are extremely straightforward. There is no mystery to how you qualify legally for the H-1. You have to have at least a bachelor's degree in a technical or professional field, and you have to have a job that requires that specific degree. And that's it. That's the H-1 process. So if you have a degree in music, you're not going to be able to use an employer for the H-1 or the green card, because people who play the piano or the guitar don't have to have a degree for anything. However, if you are in the fine arts and you're not going to be able to have an employer sponsor you, there's one thing that you can do, and that's teach. So if you are in an area where you can't qualify for an H-1 for what that degree actually does, then you want to teach, because teaching is always an H-1 category, except for Montessori schools, which don't count, unfortunately. And Montessori schools will accept any kind of degree for their teachers. And if the job requires any kind of degree, the Immigration Service will not accept it. It has to be a specific degree, and you guys have to have that degree. So those are the H-1 requirements. All of you should qualify except for fine arts, and then you need to teach. And one other small area is general business degrees. So if you want to qualify for the H-1 or the green card, you cannot have a general BBA or even an MBA. You have to have a concentration, like accounting or marketing, within that business degree. And even if you don't have the school's designation of a concentration, we can use the fact that most of your hours are in one particular area. So that becomes your concentration. So don't panic if you're getting an MBA and you take all kinds of different classes. At the end of the day, we want you to be able to concentrate. So going forward, that's what you should think about in terms of the H-1 and your business degree. Okay, let's talk about problems with the H-1, and they are numerous. The first one is actually pretty easy to explain, but it's the number one reason why employers will not process H-1s, because they do not understand what I'm about to tell you. Most of you guys are going to be paid, just to be on the safe side, let's say $100,000 a year. And let's also assume that you're going to work for 5 years instead of 7. So the company is going to pay you $500,000 over a 5-year period. They're actually going to have to pay much more than that, because they have FICA taxes. Most companies have health care. So really, instead of 500,000, it's going to be more like 600,000 or 700,000. So that's what it costs for the employer to have you employed. So if we have a $2,000 filing fee for the H-1, that means you're going to cost the employer $602,000. So that $2,000 is meaningless, right? The employer is not going to not hire you because it's going to cost them $2,000 more when they're already paying you over $500,000. So if this comes up in an interview, or you're talking to a recruiter and they say, oh no, we won't do H-1s because we have to pay those filing fees, that's what you can explain to them, is that it is a meaningless number in the grand scheme of things. As a matter of fact, counting all of the fees, which are filing fees, and there's one attorney's fee they have to pay, the employers normally pay about $6,000 to $8,000 to go from OPT to H-1 and then through the green card. So it's their burden, if you will, is not $2,000. It's actually more like $7,000. But again, what's the difference between $600,000 and $607,000? Not much. So that should not be a prohibition for a company to get an H-1. The rest of the things about the H-1 is problems Elizabeth already covered, and it really has to do with when you graduate. If you graduate in May, that means that you're going to be able to apply for the H-1 lottery the following April, actually March this year. So that gives you roughly 10 months to find an employer that will sponsor you. If you graduate in August, then your OPT is going to run from, say, August to August or September to September. You still only have one chance to get in the lottery, and it will come about 6 or 7 months after you graduate. So you have less time to find an employer than if you graduated in May. If you graduate in December, unfortunately, that's the worst from a timing standpoint, because you have to file for the lottery in March, and that means you have about 2 months to find an employer that will sponsor you. Now, if you already have a sponsor lined up before you graduate, that's great, and that's who you can use to get into the lottery. But if you don't have an employer, you might want to reconsider your graduation date to take advantage of more time to get into the lottery or register for the lottery. So there's a lot of information in our brochure about this, so I'm not going to go over all of it, but just be aware that there are different timing issues for when you graduate. So let's go. I think we can skip the next three. Lark, they're all timelines. Yeah. So we don't need to go through that again. Let's hold it right there. Okay. Let's make up a little fact situation to go through the rest of this through the H-1 and permanent residence, because I think it's easier to understand if you have a real scenario. And what you can do is take your situation and plug it into my story, and it will be exactly the same. So if your degree is in engineering or marketing or whatever it may be, it's going to be the same process with the same issues. So, excuse me, in my story, if you will, I am going to graduate from UTD with a degree in electrical engineering. I'm not even sure there are EE degrees anymore, but I hope there are. So I will have a bachelor's degree in EE, and everybody else I'm graduating with, the American citizens and the permanent residents, will also have a bachelor's degree in EE. And I don't have any experience, but I have a year of OPT, and I also have a 2-year STEM extension available to me. So if I graduate in May, I'm going to have 3 chances to get through the lottery, which is good. That's the ideal situation. So let's assume that at some point in that 3-year period, I do get selected and I change my status from F1 to H1. Notice we are talking about a change of status, not a visa. Visas are only obtained at a U.S. consulate outside the U.S., and they are only valid for travel. You do not need a visa ever if you don't travel outside the United States. Okay, it's really important because people talk about visas all the time, but what they're really talking about is immigration status. So we're going to change our status to H1, and we're going to have 6 years of H1 status available to us. Now, those of you who have been paying close attention will realize that 6 years is not enough if we have to wait 7 years for a green card. So fortunately, the government is going to extend our 6 years if we are in the green card process. So instead of 6 years, you get additional years, as many as you need, until you actually become a permanent resident. And this is very important for natives of China and India, because you will need the extra time and extend the H-1 beyond 6 years. So I have my change of status to H-1, and I'm the first one at work every day and the last one to leave every day. And the company loves me, and I'm their best employee. So at some point, I'm going to get the courage up to talk to the HR department, or maybe the owner or my manager. And I'm going to say, hey, I don't know if you remember this, but when I was recruited, one of the things we talked about was getting my green card. So I've worked for 2 years in my OPT. I've been in H-1 status for 2 years. So that's 4 years I've been here. Let's start the green card process if that's okay. The employer says, certainly. You're our best employee, so we're going to do anything we can for you. So the first thing we need to figure out for our green card is what category we fit into. So now we can go to the next slide. These are the categories for permanent residence based on employment. The ones that we're talking about tonight are second preference and third preference. And for our purposes tonight, all we care about is that second preference means the job requires at least a master's degree, and I have at least a master's degree. So if my job requires a bachelor's, but I have a master's, that is not second preference. Both things must be true. The job requires a master's and I have a master's. If one of those two things is not true, then the job and myself are going to qualify for third preference. This isn't a big deal to most of you, but it is a big deal to people from China or India, because the waiting times could vary quite a bit between third preference and second preference. It's actually a huge mess right now because of the way the Immigration Service is counting the time. But I won't bore you with all that, other than to say that by the time you get to this point where the quota becomes important to you, I hope they have it all straightened out and it won't be the big mess that it is right now. So in my situation, which category are we going to file my green card under? Well, it can't be second preference because the job only requires a bachelor's degree. And how do we know that? Because that's all I had when I started the job. So if all I had was a bachelor's, the job can't require a master's. It has to require only a bachelor's. So we know that my case is going to be third preference. So in my case, that won't make any difference if I was born in France, because every country but India and China is current, meaning there's no wait under the backlog of the quotas. So third preference is just fine. All that is a category, and it doesn't have any impact on how long our case takes. So let's go to the steps for the green card. There are 3 main steps to permanent residence through employment. The first one, labor certification or PERM, is by far the hardest and the most important. As a matter of fact, it's the hardest and most important thing in all of immigration law. If you get a labor certification approved by the Department of Labor, we can then file what's called an I-140 petition with the Immigration Service. And if that's approved, we could file for adjustment of status. Now, in the real world, we actually file steps 2 and 3 together for most people. But in terms of the legal adjudication of the case, it goes labor certification, then I-140, then I-485, adjustment of status. So those are the 3 steps we need to get through in order to get permanent residence. So on the next slide, you'll see the requirements for the labor certification. The best way to look at this is my employer has to go to the Department of Labor and prove to the Department of Labor that there are no qualified and available U.S. workers for my job. And that is impossible. If you give me enough time and money, I will find a U.S. citizen for every job. There are no unique jobs. But the Department of Labor helps us out here, And they have created an incredibly complicated regulatory scheme that if you follow all of these rules, you actually have a pretty good chance of winning. It's one of those rare cases where you don't want to cut corners. You want to do exactly what they say, and you'll be successful. Most labor certifications that are filed properly by an immigration attorney who knows how to do it, 95% are successful. So we have to follow the rules here, and the rules are really important. Now, how in the world are we going to prove to the Department of Labor that there's no qualified and available U.S. worker? Well, we're going to advertise. We're going to recruit U.S. workers. We're going to run ads in the newspaper, believe it or not. We're going to post online. We're going to do all kinds of things to recruit U.S. workers and prove to the Department of Labor that there are none that are qualified. So let's take my job, for example, and let's recruit. So we run all of the ads and we do the online postings. And the job requirements for my job have to be a bachelor's degree and no experience, because that's what I had when I started my job. So if we go out and recruit based on those criteria, how many qualified applicants do you think we'll get? 10,000, 20,000, a lot. Everybody with a double E degree is qualified. Everybody I graduated with is qualified. So we know that we're not going to use an entry-level job for the green card. We don't file those cases anymore. Many years ago, we used to file nurses that way and some other jobs that were clearly understaffed. But that's not true anymore. So we have to skip over the entry-level jobs. Well, let's say that I have worked at the company for 4 years, which I have, and the company promotes me, right? That's what you do with your best employee. So I'm going to go from engineer 1 to engineer 2. I have to do a new H1 because the H1 is only valid for one specific job. So I have to get a new H1 for engineer 2. And engineer 2 requires a bachelor's degree and, let's say, 2 years of experience, which I have. Actually, I have 4. So now we take that and we go out and recruit. We run ads and we do online postings. We get people to apply. And how many qualified applicants do we have if the requirements are a bachelor's degree and double E and 2 years of engineering experience? 500, 5,000. There's going to be a lot. And all it takes is one to lose the case. So if that won't work, how in the world are we going to get a labor certification? And the way we're going to do that is the secret of immigration. So don't tell your friends. They didn't come tonight to this seminar, so they don't get to know this. The secret is specialization. That's what companies do these days. They specialize. There's no such thing as an engineering company. There's an engineering company that specializes in building school properties. I actually have a client who does that. There are all kinds of specialties, but everybody specializes at some point. If you're in accounting, you're going to wind up, let's say, you do tax accounting for oil and gas firms. And if you specialize like that, you're going to use certain types of software, hardware. You're going to follow certain regulations. So there's going to be these things which we call the XYZ requirements. So no matter what your job is, you're going to have these. And those are going to be gained by experience. So when we go out and recruit, we don't say the job requires a bachelor's in double E and 2 years of engineering experience. We say the job requires a bachelor's degree and 2 years of experience in these 8 things. Okay? It might be 3 things. But whatever it is, the U.S. worker has to meet every single one of them. So if the U.S. worker meets 7 of the 8, we win. Obviously, if the U.S. worker only has 2 out of the 8, we win. So it's a very, very technical process, and the Department of Labor is very difficult to deal with. But if you follow the rules precisely, you can win these cases. And that's how we do it, is by focusing on the specialization that companies have these days, and certainly their employees have. So that's how we get our labor certification. And right now, that process takes about 12 to 18 months, regardless of what country you were born in. So, Mark, let's go back to the previous slide, if we can do that. There we go. So the labor certification has just been completed, and that took 1.5 years. And I started in my 4th year when I started the labor certification. So that's 4 years plus 1.5 years. So I've been with the company for 5.5 years. Now we file the I-140 petition. And if I wasn't born in India or China, I could file the adjustment of status with it at the same time, even though the Immigration Service will adjudicate them in sequence of I-140 and then adjustment of status will be and file them together. That process together is going to take another 1.5 years. So from 5.5 years, we're going to wind up at 7 years. So if somebody were to ask, how long does it take to get a green card? In my case, graduating from UTD with a degree in EE, it took 7 years. Your case might be completely different, but not the process. You're still going to go through exactly the same steps, but some things are faster than others. You might actually be able to start the case faster than 4 years. Maybe that employer will start in 2. The bottom line is you'll go through the same process and you're going to wind up 5 to 7 years later having a green card. And that is the requirement for permanent residence through employment. It is not something that you voluntarily do. When you apply to companies, you don't say, I promise I'll stay with the company for 7 years if you hire me. The company's not going to hire you based on that. What they will do is hire you if the law requires you to be with a company for 5 or 6 or 7 years, and you don't have any choice. That the employer likes, and they should make a job offer to you based on retention. So that's why all these steps are so important, because they keep you with the employer long enough for them to want to sponsor you. Otherwise, they wouldn't sponsor anyone. So I think there's one last slide, Lark, after that one. Yeah, that's in the brochure, and I won't waste your time with my thoughts on how to seek out a company and get them to offer you a job. But if you want to read that, it's in the brochure, and you're certainly welcome to. So that's what I have for tonight. I know we went through it pretty quickly, but I think this virtual stuff kind of requires that. And hopefully next year we will be live and in person for the first time in 3 years. So that'll be much better. Thank you very much. And we are open for questions.
Yeah, we do already have a couple in the chat. So the first one is, can I personally apply for NIW if I qualify?
Yes, you do not need a sponsor for 2 kinds of cases, NIW and extraordinary ability of first preference, those who can self-petition.
All right, great. Looks like next one is kind of a series of questions. So 1, I'm changing jobs from a non-sponsoring company to a sponsoring company. So by when should I be hired to be qualified for the H-1B application?
When can you be qualified?
I think what they're asking is by what point in time do they need to be hired by the company in order to actually apply for H-1B with that company?
Well, anytime after you have at least a bachelor's degree in a job that requires a bachelor's degree.
Right, and then I assume before the April opening of the application period?
Well, if it's not a university, then we have to go through the lottery. So you would register in March. And if you're selected and win the case, you would change your status on October 1st of that year. And obviously, if you're not selected in the lottery, you have to figure out a way to stay in the U.S. and continue working until the following year. And there are ways to do that, by the way.
All right, the follow-up question for that one is, how many years after H-1B will I be eligible to apply for a green card? And do I need to stay with the same employer from H-1B to getting approved for a green card?
Well, let's take the second one first. How long you're with the employer is dictated by how long it takes to get a labor certification. And that is dictated by what the job requirements are for your position. So in other words, in my example, I didn't have any experience when I started, and the job didn't require any experience. So I know we can't use that. So I'm going to have to work for 2 or 3 years to get experience. So the amount of time is dictated by the job requirements and what my experience is. It's not dictated by, okay, after 2 years of the H-1, you have to apply for a green card. It's not like that. It's based on the practicalities of each case. When do I have specialized skills in a particular area and a job that requires those specialized skills? That's when I can start the labor certification. And I forgot the first question.
I think it was just, do you have to be an H-1B for a certain amount of time to be eligible to apply for the green card?
No, you do not. What you have to do is what I just explained. You have to have a skill set and a job that requires that skill set. So you might be able to do that in year 2 or year 4. Every job is different. Every company is different. Keep in mind, however, that if the green card process takes 2.5 years, you don't want to start in the 4th year of your 6 years, unless you can get to a certain point where you can extend the H-1 beyond 6 years. But that's really playing with fire, and you just don't want to do it. My recommendation is to be safe. You should start your green card case by year 3 of the H-1. You don't have to, but if you don't, then it's going to make for a very hectic 4th and 5th year of your H-1 status.
All right. Okay, next one. So my employer has agreed to file for H-1B and my application got selected in the lottery. However, they aren't keen on hiring an immigration lawyer and want to file the petition themselves. They don't really have prior experience with the process. Would this be risky? Is there anything that they need to pay attention to, and any advice on the process that I can pass along to them?
Well, first of all, the law does not require that you have an attorney or the company has an attorney. 20 years ago, I used to say, if the people at the company are really smart, they might be able to figure it out. I honestly do not think that a company will do it correctly, even if they're successful and immigration approves the case. It's going to come back to haunt them when we get to the green card process. So my short answer is, yes, it's very risky.
All right. Does the size of the employer matter? For example, does a larger company versus a smaller company have a different outcome when it comes to applying for H-1B?
This is a good question. In our experience of 42 years or whatever it's been, big companies fall into 2 categories. They either do the immigration all the time, they have their own in-house attorneys and paralegals, and they take care of everything themselves. That's like Microsoft and Intel, the big 3 accounting firms. They all take care of all that themselves, and they're very good at it. And the other part of big companies is they won't touch immigration with a 10-foot pole. A lot of banks are that way. Some companies are very frustrating because they will sponsor you for an H-1, but not a green card. JCPenney's used to do that. And it was very frustrating because you really liked your job and you really did a good job, but you knew that you couldn't stay there and get a green card. So those are the types of big companies. When you talk about medium and small size companies, they're all over the place in terms of what they will do or won't do. I personally prefer medium and small size companies because it's easier to deal with the people who work there. Big companies have a lot of bureaucracy. They had a lot of rules that nobody knows where they came from, but by golly, we're going to follow them. Whereas small companies and medium-sized companies are more flexible. So I prefer working with them. However, the size of the company doesn't matter in terms of the immigration process, except the company has to have the ability to pay your salary for the H-1 and the green card. And obviously, smaller companies may have difficulty with that. Startups are especially bad. But we can usually get away with the H-1 on a startup, but that company has to be doing very, very well after the first 2 or 3 years in order to do the green card. So the only reason size matters is the ability to pay the salary.
All right. What is the current waiting time for green cards for Indian citizens right now?
For natives of India, my best guess right now is 7 to 9 years in either second or third preference. The visa bulletin actually is longer than that. I think it's up to 15, but I don't think that's a realistic prediction. I think the quota is going to speed up, and it is very likely that Congress is going to add to the quota. They're going to make more slots available. Now, I know that's kind of going on a limb because Congress never does anything. But if anything does happen in the immigration world, I think that's one of the things we're going to see in the next few years because it's literally stifling competitiveness. It's very bad for the country as a whole. And I think even the people in Congress are starting to realize that.
All right, you mentioned about getting a specialized position in a company to ensure the highest chance for the lottery. What advice do you have for a non-STEM student who will only have 1 year of OPT?
Well, obviously, you're going to be able to apply one time. And if you're not selected, then you've got a couple of bad choices, or actually 3. One of them is if the company can allow you to work virtually, then you can do that outside the United States. The other option is the company may have an office outside the US that you could transfer to. But if you can't do either one of those, all you can do is what we call upfront CPT, and it's called different things by different people. But basically what it is a graduate program of any kind, although obviously best if it relates to your bachelor's. And the school will give you full-time CPT from the first day of school. You may have to take a class online, but a lot of these programs, you don't have to do anything. There are no schools that I know of in Texas that will do this, and that's a matter of policy. There is some debate about whether or not this is quote unquote legal. I'm of the opinion that it is not only allowed, it's not only not a violation of the regulations, it's allowed by the regulations. But anyway, you'll have to find a graduate program that will do that. And one of the ironic things about this is you're looking for a bad graduate program. And the reason for that is good graduate programs don't have any openings for students who aren't going to be there. They don't want to have somebody on CPT who doesn't even show up for class. However, if you have a not so good graduate program that has lots of openings, that school and that program would love to have you because you're paying tuition and you're not even using their services. So those are the 3 options if you're not selected in the lottery.
Just as a follow-up to that, if any students do have questions about how that CPT works and why it is kind of questionable, or at least in a gray area, feel free to come in advising with our office, and we can kind of talk to you more about it and why that is. All right. So we do have a couple of questions on, so if you're not selected in the lottery, what are your alternatives to stay in the U.S. if you're not able to, sorry, if you're not able to, if your OPT expires before you can get to the next filing period?
Well, the three options I just mentioned, those three are available if you want to work. Now, if you don't care about working, then obviously you could just continue your education and go into a graduate program or even another bachelor's degree. But if you do want to stay employed by a company that could sponsor you for the H-1 and the green card, then you're going to have to do one of those three things.
Is it possible to apply for a green card directly from OPT, or do you need to go through the H-1B first?
You can apply for a green card when you can get a labor certification, and you can get a labor certification when you have a job that requires special expertise and you have that expertise. So it's not a matter of 1 year or 2 years or some legal requirement. It's a matter of practicality. When can you win a labor certification? And if you can do that off your OPT, great. We have, in fact, processed some green cards for people with STEM OPT. It's a little tricky on the timing, but if you have a cooperative employer, that's possible to do. So there's no H-1 involved. But most people are going to wind up having to do an H-1, even STEM OPT, just because of the time it takes to get those skills and then get a promotion to a job that requires those skills.
Okay. Okay, so do companies that have a track record of sponsoring H-1B have a better chance of getting other H-1Bs approved?
No.
Not really.
Each case is based on its own merit.
Okay. One person's asking about what documents that they need to file. I think that might be better in a email. Do you have any insight on what the current processing time for green cards for Pakistani students is right now?
Natives of Pakistan are in the worldwide quota, so they're the same as people born in France. The only two countries that are different are India and China. Everybody else is the same.
Okay. If there has already been a family-based green card application done and it's waiting in the queue while on OPT or H-1B, and the only option next after H-1 is to continue working, hold on. Oh, I see what they're saying. Okay, so they're basically saying if they already have a family-based green card in the works, would applying for a second work-based green card, would the two applications conflict with one another?
They do not conflict, and in some cases that is going to be required because most family quotas for people over 21 can be anywhere from 6 to 11 years waiting under that family quota. And if the H-1 is going to run out, the only option is to start the employment green card in order to extend the 6 years of the H-1. So we've actually done that before where the person didn't get permanent residence through the employer, but we got about halfway through the case when their green card was approved under the family quota.
It looks like the next question was actually for us, but Lissa answered it in the chat. Okay, so can an employer file for H-1B for a remote location? But I suppose that's permanent remote work.
It depends on where that location is. If it's in the United States, yes. If it's outside the United States, we don't need an H-1.
Right. Okay. What is the total application fee for applying for H-1B? Is there any waiver for those students who have small companies who may not be able to pay for them?
There's no waiver for employment-based cases because the employer has to prove the ability to pay the salary. The cost is the same regardless of the size of the company. The average for an H1, if you count everything, is probably around $6,500 for attorney's fees and filing fees. But that's just an average. It could be less, it could be more.
All right. And it looks like someone just wanted some clarification on what exactly qualifies for the first preference of the green card.
First employment preference?
Yeah, the number one category.
Well, we have extraordinary ability, which is the first category. And those are the people at the very, very top of their occupation, whatever that may be. They are world well known in the world. They're at the top of their field, and they have to have international recognition, which is at least 2 countries. So if they're really, really, really famous in Austria, but they don't do any work or give papers or do anything outside of Austria, that won't work. So we have to have at least 2 countries. The second EB1 category is outstanding professors and researchers, and that requires at least a master's degree and 3 years of experience, mainly research experience. And then the third category is certain managers and executives, and those are really cases where somebody's been transferred from overseas from one office to another office of the same company. So those are the 3 categories.
Okay. Is there any constraint that requires you to reside within a certain number of miles of your office location when you're on H-1B?
Yes. The what's called labor condition application is a prevailing wage that's set by the Department of Labor. And those prevailing wages are based on what's called SMSAs, which is a metropolitan area defined by the Department of Labor. And if you live inside that area, then that prevailing wage is whatever applies to the office itself. But if you live outside of that area, it can be a different prevailing wage than what you would have with the company. The short answer is that living outside of the standard metropolitan statistical area can make it a different prevailing wage than if you lived inside that area.
Okay, I think this person is referring to, okay, so I know that personally last year that there was a thing that happened with H-1B where some people were waitlisted, and then there was kind of a secondary lottery that was pulled later in the summer. So I think what this person is asking, so they're saying, is there going to be another round of lottery for H-1B this year? And what are the chances of it getting picked in this round? So I think they're just asking, is there going to be another wait listing like there was in 2021?
The second round of the lottery depends on how many H-1s are denied in the first round. The Immigration Service essentially gives out 85,000 H-1s the first time for the basic lottery, but not all of those are going to be approved. So let's say 5,000 of those H-1s are denied, then the Immigration Service will have a second lottery with the people that were left over from the first lottery who didn't make it. And they'll go into that second lottery and they might get chosen in that. But it's hard, it's impossible to say how many there are because it depends on how many cases are denied.
Okay, the next question I think is more for me and Lissa. So if you apply for the H-1B lottery in March and your OPT expires in May, should you apply for the cap gap or apply for STEM OPT if you STEM OPT instead if you qualify for it, given that you don't know the result of the H-1B yet?
I would apply for both.
Yep. I would agree. Just to kind of get some more information, you can apply for H-1B and STEM at the same time. Whether you do so is ultimately up to you. It's really your choice. But it's very, very common for students to apply for both so that the STEM can kind of act as a safety net, just in case something doesn't go as planned with the H-1B, then at least you have another work authorization to fall back on.
Absolutely correct. That's the best way to do it.
Okay, we've already answered that question. Can I apply for a green card on the first day of my H-1B on my own?
You can apply for a green card when you have a set of skills that make you an expert and you have a job that requires those skills.
Yeah, so it's basically just going to be dependent on when they can get that verification completed, correct?
Right. You've got to be able to get a labor certification, and in order to get a labor certification, you have to show that there's no qualified U.S. workers for your job, and that in turn requires you to be an expert or have special skills, and then a job that requires those skills.
Okay, and looks like this is our last one so far. So if you have a master's degree, are you more likely to win in the H-1B lottery? I've heard that the first 20,000 get kind of a freebie. Is that true?
Well, 20,000 are set aside for people who graduate with a master's degree in the U.S. So math is not my forte, but I've been told that there is a statistical advantage to having a master's degree from the U.S. I don't know how large that advantage is, but I have been told by people that I trust their opinion that there is a difference.
Okay. All right. That looks like all of the questions that we have for now. Oh, I have had a couple of people ask for your email. I'm going to send a follow-up email to send them the documents that you provided to us before the session. Is it all right if I just include your email when I send those documents?
Absolutely. I encourage students to, or faculty for that matter, to email me if you have any questions. I'm happy to answer them, as long as it's not something like, how do I get a green card? Because I don't type that fast. So if you have specific questions, I am more than happy to answer them.
All right, sure thing. Hold on. There's one follow-up question from an earlier. So the one about the prevailing wage difference. So if my employer is in Oregon, but I'm in Texas and the job is fully remote, which state would the prevailing wage determination be sought for H-1B?
In that case, it would be Oregon, and it would be the specific SMSA for that location.
Okay. All right, great. Well, I think that is a good place for us to wrap up, unless you've got anything else that you would like to add before we go.
I do not. I thank everybody for coming, and good luck the rest of the way.
All right, fantastic. Okay, so everyone who's here, like I mentioned before, I'll send a follow-up email before the end of tomorrow to share the documents that David shared with us, and to also provide his email address for reference. And this should be posted in video format on our YouTube channel within a week or two, as soon as we're able to get the video edited for it.
Great. Thank you. And also, thank you for your patience in getting this set up. I know I'm not the best technician in the world, but you guys are champions, so thanks.
Yeah, thank you too. We were not expecting this much interest, so thank you for helping us pivot as we tried to move it to a new platform.
Great.
All right. Well, thank you very much, everyone, for attending. You have a great rest of your week.
Thank you. Bye-bye.
Bye-bye.